That's when the CPS investigator kind of drops out. They don't come to the dispositional hearings unless there's some issue and there's going to be testimony, and the foster care social worker will take it from there. The county attorneys are assigned cases and are basically they follow the cases. I've had cases going on for the entire time I've been at the county attorney's office that never seem to go away, and I wish I could give them to other people, but we have to keep them. So we keep them, we go to all the hearings, we are pretty intimately involved with the facts of the case and the situation with the family. And then you all, the CASA, are also charged with initiating an investigation into the facts of the case and looking out for the child's best interests. Generally speaking, we try to avoid having children come to the courthouse for the hearings. Sometimes, unfortunately, we can't avoid having kids testify if there's no other evidence of the abuse other than the child. So when we do have to have kids come to court, we call it the DFS room. We have a room in the downstairs of the courthouse that's got toys and books and things for kids to play with, so we can bring them down to the DFS room so that at least they're not up in the hallway looking at everybody and wondering what's going on before they testify. And that's a good place for you all to meet kids if you haven't met them yet. It's a good place for us to interview kids if they are going to have to testify, and sometimes we do that there. After the final child protective order is entered and services are put into place, generally speaking, we don't go back to court for review hearings. The social worker just goes on with the family and keeps working with the family. There's a couple of ways to get back to court. Sometimes the judges will set review hearings for protective order cases, and usually they'll set them for about every 6 months. And they do that for families who we think are probably going to be the kinds of people who aren't going to do anything unless they know they're coming back to court to stand in front of the judge and potentially get in trouble. So if we think it's going to be a hard case, then we'll set them for review so that we can bring people back and we know they're coming back to talk to the judge.
Yes. Which social worker? The CPS or now the foster care?
It's not either. There are ongoing workers who provide protective supervision for kids who are not in foster care, but that they provide services to. We call it protective supervision. So there are separate social workers who don't deal with foster care kids. They deal with kids who remain in the home, but they're not CPS, they're DFS. And those social workers are the ones that keep working until they feel like we don't need to be involved anymore. When the social worker makes a determination that the court doesn't need to be involved in the case anymore, then we go back on motions called motions to end protective supervision. And we usually do those on motions dockets, which are Wednesday dockets. Generally speaking, they're agreed orders. Protective supervision can last for about a year. A lot of times it lasts for more than a year. County attorneys, if we don't go back to court, county attorneys don't really keep up too much with the cases that are protective supervision cases because we've got so many foster care cases, unless there's a problem. So sometimes I'll get an EPS request from a social worker on a case that I haven't even thought about for a year and I didn't even know that we were still involved. But the social workers stay involved. They go out, they visit the children about once every month. That's the minimum. If they feel like they need more, then they go more often than once a month. If families, namely parents, are not doing what they're supposed to be doing, either under a foster care case or a protective supervision case, any case where they've been ordered by the court to do something, then the department can also come back and file what's called a rule to show cause. And that is a separate petition or a separate warrant that's issued by the court that basically charges the parent with contempt for not following the court's orders. The Department of Family Services doesn't use the rule to show cause that much. It can be an effective tool. However, generally speaking, what happens if you are dragged back into court under a rule to show cause, the judge really just has the opportunity to put you in jail. And if your parents are in jail and you're not in foster care, then that's a really easy way to end up in foster care. So we try not to do the rule to show cause unless it's a really serious situation that this parent kind of needs a knock on the head to say, hey, this is what's about to happen to you if you don't do what we've asked you to do. So those are the ways to come back to court on a protective supervision case. It doesn't happen that often. Really, our time outside of the emergency hearings that we have, our time in the county attorney's office and your time as a CASA is going to be spent with the foster care cases that keep coming back into court. There are several goals for foster care cases, and I'll go over them. I've already talked about the return home goal. That's the obvious one. We're trying to return the kids to their parents or their prior custodians as quickly as possible. Relative placement is also something that I mentioned. The department is tasked with exploring relatives as placement options for children. So sometimes if the parents are giving us a hard time about it, we'll order in the court order that the parents have to provide all contact information for any relatives that they can think of. A lot of times we order moms to turn over any information that they have about biological dads, because a lot of times they don't want the fathers of their children who are not currently involved to realize that they've gotten themselves in a bad situation, because they don't want the dads stepping forward to say that they want custody. The department has to explore whether there's a father out there who is interested in having custody. So sometimes we have to order the mothers to turn over that information. Once that information is turned over, then the social worker, who is going to be the ongoing foster care social worker, is the person who contacts those people, asks whether they're interested. If they say that they're interested, then we do a home study. We do criminal background checks, and we talk to them about the process for either being a foster care placement or for obtaining custody of a child. If the potential placement is outside of the state of Virginia, then there is a federal law that kicks in and requires us to go through what's called the Interstate Compact for placement of children. DFS can't place a child across state lines without going through, it's called the ICPC. They can't place a child without going through the ICPC. Basically what that is the state of Virginia ICPC office. All states have ICPC offices. So Virginia's ICPC office will contact the office in the other state, wherever the placement is located. And then that Department of Family Services will do the home study for us. They do the background checks. They keep up with the family. And if that placement is approved, then we send the child while Fairfax retains custody. The social worker in the receiving state works with the family, usually for 6 months, and then we transfer custody. So if a family member is identified and the parents don't end up doing what we ask them to do, then generally speaking, that relative will get custody. If the child is young enough and the parents have done so little that we don't have any hope that the family is going to be reunified, then occasionally we'll go forward with trying to terminate parental rights so that the family can adopt the child instead of just being the custodian of the child, which is in the child's best interest. The younger they are, the better it is for them to be adopted and have real permanence. If we're not looking to return home, or we can't find a family member who would be willing to take the child, then really depending on the age of the child and the child's situation, we have to start looking at the other options. If the child is younger, then we really look to terminating parental rights and trying to have the child adopted. And like I said before, obviously it's in a child's best interest to have a permanent home, to not be languishing in a situation and never know, is mom going to come back 5 years from now and petition the court for custody. So the adoption goal as a foster care goal is really a last resort for the department. But unfortunately, it's one that we use quite often. With older children who have a relationship with their parents and want to maintain a relationship with their parents, or if it's in their best interest to maintain a relationship with their parents, then there's some other options as well. If a child is 12 years old or older, then we can put them in what's called permanent foster care. That maintains the relationship with their parents, or can maintain the relationship with their parents, but it places them in a permanent foster home. And the foster parent or foster parents in that home sign an agreement with the department that they agree to be the child's foster parent until they turn 18. That agreement is incorporated into a court order, and it's almost as good as an adoption. You can go into court and dissolve it if something happens and it needs to be dissolved, but it's as permanent as it gets for kids who aren't going to be adopted. Sometimes when kids get older, or if they have behavioral issues or mental health issues, then they'll be in a foster home and the parents will say, we don't want to adopt, but we're committed to this child. We want to do what we can to try to raise them until they're 18. So the permanent foster care solution becomes a viable option for some of those children. Once a child in foster care attains the age of 16, if it's not looking like they're going to be adopted, then we can do what we call independent living as a goal. The child has to be 16 years old to do independent living. And basically that just involves the social worker and the foster parents agreeing to start working towards teaching those kids how to budget, they get a job, how to maintain a checkbook, those kinds of things, how to write checks, how to keep your bills straight, so that when they turn 18, they can go off and with continued support, hopefully from the department, can get jobs and can be functioning adults. The group homes that we have that we send children to who have behavioral problems also have separate independent living programs. So if we can approve a goal of independent living, then a lot of those kids, when they're 16, 17 years old, get placed in an apartment. They have an apartment, they have a job, they go to school, or they're getting their GED. They have roommates, and they really kind of learn how to live on their own before they turn 18, so that they've got a fallback support system with their group home program and with the department. The final goal, before I go back and talk a little bit about adoption, is what's called APLA, and that's APPLA. It stands for Another Planned Permanent Living Arrangement. APLA is something that we use for kids who are in foster care who have such severe either mental health problems, mental retardation, kids who really are not going to be cared for in a home within the next 12 months, 18 months. Then we approve a goal of APLA. Those kids are always in a residential treatment facility with no end in sight. So instead of coming back to court saying, what's going to happen with this child now, what's going to happen now, we say, look, we've gotten to the end of the rope here. This child's not going to be stepped down out of that residential facility in the near future, so we need to keep them there. So we approve the goal of APLA. The reason that we have that as a fallback is because pursuant to statute, we really have 12 months from the time the child comes into foster care to approve a permanent goal. After the dispositional hearing, we set these hearings for 6-month reviews. And there's one foster care review, and then we start getting into what we call permanency planning hearings. In theory, by the first permanency planning hearing, we're supposed to have come up with a permanent plan for this child. That is mandated by federal statute so that we don't have children who are just in foster care, no real reason for them to be in foster care. They could be doing something else, but we're just keeping them. So we really are marching down a very strict timeline. So if we get to children who have such bad problems that we're not going to be able to create a permanent plan for them in a home with somebody in 12 months or 18 months, then we put them in the APLA category. When they are ready to be stepped down, if they ever are, from their residential treatment program, then we go back to court on a new petition and we say, hey, we need to change their goal to adoption or to independent living or permanent foster care because they're ready to go back into a home setting, or they're soon to be in a home setting. So APLA is not a permanent thing. We can change it back, but it just buys time for kids who really need that residential treatment. Adoption cases, as I had stated, are kind of the unfortunate result of what we do, and they are the worst cases of the worst. They are the cases where the parents are just not in a position to take back custody of their children. Most of the cases that we have that come in for termination come in after 12 months, and it's a termination because the parent hasn't followed the court orders, the parent hasn't remedied the situation that was in effect that either caused the child to have to come into foster care or caused the child to have to stay in foster care. The termination of parental rights statute is 16.1-283. There are many ways to get to a termination of parental rights. In a lot of cases where we have either unknown fathers or fathers where we have a name but no location, or parents who are incarcerated somewhere, we don't really know where, but we haven't had contact with them, then one of the subsections of this code section is basically the abandonment section, that the parent has not contacted the department within a reasonable period of time, and it can be either 6 months or 12 months, depending on the situation, to make a plan for the child's future. Parents who are involved with the department and with court services come under, we call it C2, it's subsection C2 of that statute, and that is that their rights are terminated because the parents, without good cause, have been unwilling or unable within a reasonable period of time, not to exceed 12 months, to remedy substantially the conditions which led to or required continuation of the foster care placement. And the catch to that C2 is that the department has to prove that they have provided rehabilitative services to the family and that those services either didn't work or they weren't accepted by the family. And if the department can't show that they offered services, then the termination is never gonna go. So we have 12 months basically to offer services to families, try to help them get to a point where they can take custody of their children, and if they can't, then we go to termination. Once the parental rights of a parent have been terminated, then the parent becomes a legal stranger to the child. They can never come back and attend a hearing. They can never again file for custody. They can't file for visitation. They don't, it would be like one of us filing for that child. They don't know the child under the eyes of the law. So it's a very severe remedy. But the flip side of it is that it frees up a child for adoption. And then we have a separate adoptions unit within DFS who works to place children in adoptive homes. A lot of our foster families are what we call foster to adopt families who take in kids. And if we end up terminating, then we try to work with the foster families who have been caring for these children to adopt them, especially with the younger kids. A lot of the younger kids that we have in foster care, their foster parents are their parents because it's the only real care that they've received and they're the only parent that they've had. So we try very hard to keep kids with foster parents when we can. There are other ways for children to get into foster care, and generally speaking, I don't see CASAs appointed to these kinds of cases. Generally, the CASAs are appointed to the abuse and neglect cases, but I'll touch on them just in case you wonder what all the other people are doing in the courthouse while you're there. There are delinquency cases, and under disposition in a delinquency case for a juvenile, one of the options is to place the juvenile in foster care. Another type of petition is called a CHINS petition, and those petitions are child in need of services or child in need of supervision petitions, where a child, habitual runaway is one way to get to a CHINS petition, kids who don't go to school, kids who have substance abuse problems. Sometimes their parents will come in and file a CHINS petition because it opens up a lot of avenues for the family to get services if they can't afford to seek out those services themselves. Sometimes kids come into foster care under those CHINS petitions because their parents just can't handle them anymore if they've got such severe problems. Occasionally and unfortunately, sometimes parents file for relief of custody of their kids. Sometimes parents sign entrustment agreements with the department. Both of those are mechanisms to get children into foster care. The relief of custody petition is a petition that's filed by the parent or the custodian. And then once that's filed, intake makes a referral to the department, who then does an investigation to see whether the child should come into foster care or whether we need to provide services and try to keep the child in the home. An entrustment agreement is basically a contract that a parent signs with the department outside of court in order for the child to be entrusted into foster care for a period of time. It could be 3 days, it could be 30 days, it could be 90 days, or it could be permanent. Within a specified period of time after signing the entrustment agreement, the department then has to come to court and file a petition for approval of that entrustment agreement in order to solidify that the child's going to be in foster care. Judges can also put children in foster care under really any petition that comes before them, custody petitions, really any child that finds themselves in front of a juvenile court judge could end up in foster care. That's not a good way to say that, but the judges have a lot of leeway to take care of kids who come before them, and if they see issues, I've been called on my cell phone when I've been driving home saying, hey, you need to come back to the courthouse. I've got this child. I'm not letting him go home with his parents, and I have to turn around and go back and call the social workers, have them meet me at the courthouse to try to find a place for kids to go. So those are kind of the other roads to foster care that you guys probably wouldn't be involved in, but just for the sake of knowing, I wanted to mention them. That basically is the court process that you all will be involved in. And I've got a little bit of time, and then I've got some extra time past 7:10. So if anybody has any questions, go for it.
When you're the county attorney, who are you representing?
That's a good question, and I didn't say that. The county attorneys represent the social workers. In theory, the county attorneys represent the county. We represent the county's interest in cases, but for all practical purposes, the social workers are our clients when we get to court, and we work with them and we do what they ask us to do unless there's some real good reason not to. And usually there's not.
That administrative process that precedes our involvement, who's the tribunal or the...
At the local level, there is a local hearing officer who actually works for the Department of Family Services. His name is Jim Pope. He hears the administrative appeals. Basically, because it's an administrative process, the appellant, who in those cases is the person who's been deemed to be the abuser or the neglector of the child, has to take their case before the department and say, hey, your workers have wronged me, and here's how they've wronged me. I didn't do anything that I should be punished for. So when they first go, they go to the hearing officer who works for the department. If they're not happy with that result, then they can appeal that, and then it goes to a state hearing officer. But that person also works for the State Department of Social Services. So you're still in the agency. So you take your case to that person. If they say, no, the social worker was right, you did something wrong, this should have been a founded determination, then you can appeal it to circuit court. And then we go into court. The Attorney General's office is the entity, the legal entity, I guess, that defends the state in those cases. But sometimes if it's a case that we're involved in, we'll go hear the argument. And basically, the appellant then has to show to a circuit court judge that the social worker had no reasonable basis to make the determination that they made. If you get into the appeal process as an appellant, it's pretty hard to win. And the reason for that is that what happens to people who are, I guess, the subjects of the founded determination is, depending on what level of abuse or neglect you're talking about, that's how your name gets on the CPS registry. So you can't be a teacher, you can't be a coach, you can't be a daycare provider. So generally speaking, that consequence isn't such a heavy consequence that we feel like we need to take it out of the administrative process. So those people have a really hard time proving that the decision that was made by the agency was incorrect. I've seen it happen, but it doesn't happen that much. From the circuit court, they can go to the Court of Appeals. I mean, you can keep going as far as you want to go, but that's basically, I don't think I've ever had one that's gone to the Court of Appeals. It doesn't happen that much. But that's the process. It's an internal process mostly. Mm-hmm.
This is a little sidebar. Do you all get involved in the cases like that Montgomery County case where the mother was saying the father shouldn't have privileges, and then?
Well, yeah, absolutely. We get involved in a lot of cases like that are very messy because there's the underlying custody and divorce situation that's going on. At this point in that particular case, obviously CPS wouldn't get involved because the kids aren't alive anymore, but that mother potentially could have called CPS at any point saying, here's my ex-husband has mental health problems, he has visitation with my children, and I don't think he should have visitation with my children. Can you do something about it? The problem is that CPS really kind of tries to steer clear of cases where, like that case, had already been tried in front of a judge. So all we would do is bring it back to be tried in front of a judge. So if it's already been there and a judge has already made a decision in a custody case, then unless something new happens or something dramatic happens, we try to stay out of it because we don't want the judges and the courts to see the department coming in and trying to undo what is already a court order. But yeah, we do get a lot of referrals on those cases. A lot of times parents, unfortunately, will call CPS right before their custody trial to try to get the other person in trouble so they can go to their custody trial and say, oh, CPS is investigating them. And we actually go to circuit court a lot on petitions. If you are the subject of an unfounded complaint, then you can file a petition basically suing the department to compel the department to turn over the name of the person who reported you. Generally speaking, that's confidential information, but a circuit court judge can order the department to turn over that information. And if that person can show that, that the complaint was made without a good faith basis, then potentially they could find out that their ex-wife or soon-to-be ex-wife or ex-husband had called CPS on them. And then they flip the tables, and actually that information can be used in the custody hearing. And that's if it comes out that you've made an unfounded report against somebody that you're in litigation with, and that looks very bad for you when you get to court. So yeah, we do have those that come in all the time.
Would an allegation like that of like imminent danger, like I think my ex-husband's going to kill my kids or has disappeared and might kill them, would that come with, I mean, it's not sexual abuse, it's neglect, I guess, or it's not.
Well, yeah, I mean, it is.
Is that a criminal allegation then, or does it fall?
It depends. If there are criminal laws related to parents abducting children that they've got, that they don't have primary custody of, and if you abscond the jurisdiction under a custody agreement, then that can be a criminal act. But it also would fall under abuse and neglect if that parent has mental health problems, or if somehow the reporting parent knows that that parent has absconded and doesn't have any intentions of coming back, then yeah, that would fall under the abuse and neglect statute. And actually, even if we haven't removed a child, we can still go to court and file to have custody of a child. So in that situation, if we know that a parent has absconded with a child, sometimes we have protective orders where the family starts to backslide. We start talking to them about, hey, we're going to have to go back to court. This may end up with your child being in foster care. You need to do what we're asking you to do. And then all of a sudden at the next home visit, the child's not there, the parents aren't there, they've moved out, we don't know where they are. Then we can go to court and file a petition asking the court to give us custody so that when law enforcement finds them, then we can take the child. That doesn't happen much, but it occasionally happens. Anybody else?
I just have a question. The 5 days, the 5-day hearing runs from once the order is issued? Is that when the clock starts? Or is that 5-day hearing is just called that?
For a protective order, the hearing is 5 days after the ex parte order is entered. For a removal, though, it's 5 days after the child was removed. And it's 5 business days, so we don't count weekdays or holidays, or weekends or holidays. I'm sorry?
Is there a reason for
For 5?
years?
No, no reason. And it actually, it's kind of puts us in a difficult position to have to prepare for trials always over a weekend. Sometimes they're medically involved, there's doctors, there's all kinds of witnesses, so it's a little stressful when you have your 5-day hearings if it's something contentious that's going to be tried.
What happens if a child is in a foster care situation, commits a crime? Do they then fall out of the juvenile system?
It depends. We have, generally speaking, kids who are charged with crimes while they're in foster care are appointed a public defender who then represents them. DFS and the county attorney will attend their criminal hearings because we're really the parent of the child, and by statute the parent has to go with the child as long as they're under the age of 18. A lot of those kids can't be maintained in their foster home because the foster care agency won't take a kid, depending on what the crime is. A lot of foster care agencies won't take kids who have been convicted of crimes or found to be delinquent of crimes. So they wouldn't automatically be bumped from the system as long as they're under the age of 18, but we do place them in residential facilities sometimes. If they can't be maintained in a foster home, then we kind of have to up the level of supervision. There's unlocked residential facilities, there are locked residential facilities that we try to deal with kids who commit crimes, especially the ones that are committing, violent crimes or assaultive crimes. Once they're 18, kids who turn 18 can continue to receive services from the department if they're in foster care until they're 21. And actually the department will pay for college. The department really provides a ton of services to kids when they turn 18 if they don't have families, so they can, kind of get themselves on their feet. But if an 18-year-old who is voluntarily receiving services from the department commits a crime, then that's a done deal. You're out, because we're not going to spend that money on somebody if you're not going to be, bettering yourself and so on and so forth. But we can't kick kids out of foster care. If we have custody of a child, then we're pretty much stuck with that child until we can find a relative or somebody else to take custody. I've had cases where we've come back 6-7 placements, desperately calling people before the criminal hearing, please will you take this child, please will you take this child, because if the court has to release them, kids can only stay in juvenile detention for so long, so when the courts release them, they're ours and we need to find a place to put them. So sometimes that puts us in a really bad spot.
If a child's been sexually abused by one of the parents, and I assume they have to get therapy, how long would that go on, and how can they determine whether or not that's going to happen again by whatever therapy they've gotten?
How do they determine whether what's going to happen again?
The parent is ever going to do that again. I mean,
Well,
a psychiatrist for X amount of months, and then they have to determine whether or not the parent they think the parent will do it again?
that really is a case-by-case basis. Generally speaking, if there's 2 parents in a home and one parent abuses the child sexually, then the social worker will go in and say to the remaining parent that you need to make a plan to protect your child from this person. That may involve you moving, it may involve kicking that person out of your home, but we're looking for you to take steps to protect your child. They can file protective orders, all that kind of stuff. If that parent is not willing to do that, then CPS goes to court and we get a protective order. That the protective orders actually have a clause that can remove someone from the home until further order of the court. Or in the real bad cases, when we have the remaining parent who's the non-abusing parent who's saying, you know, I can't afford to live on my own. I can't afford for him to not be giving me money. He needs to live in this house. You need to send her to live someplace else. I mean, there's some really bad situations that arise out of those sexual abuse cases. Then we take those kids into foster care. Those kids always get their services. We order what's called a psychosexual evaluation for the offender. A lot of times that's put on hold by the defense attorney in the criminal case until the criminal case is over with. I'm searching my brain trying to think of a case where I ever reunited a sex offender with their victim, and I can't think that it's ever happened. I mean, everybody has a lot of personal beliefs on that stuff, but it just doesn't, there's not a lot of hope of reunification. So it's not something that happens, really.
I've been doing this work since about 1972, a little over 35 years. And one of the biggest changes that happened in abuse and neglect work is when CASA started appearing in cases. And I can remember somebody started showing up in the courtroom and we didn't know who they were or what their role was. But that was sort of the beginning of the point where children became the focus of what was going on in an abuse and neglect case. Up until that point, it had all been, what the parents were doing, and there wasn't a whole lot of focus on children.